Hello. I think we'll go ahead and get started. And usually we have some people come in as the event goes just because classes get out around this time. So just feel free to come in and take a seat as you come in. All right, so welcome everyone. My name is Erin Mayo Adam. I'm the director of the LGBTQ Policy Center here at Roosevelt House and a professor in the political science department, and I'll be moderating this today's event. I was accidentally left off the program, which is totally my fault, not anybody else's fault. I forgot to send my own bio, so I'm the moderator. I'm delighted to moderate today's event, which will be on LGBTQ rights and the Supreme Court is our topic of discussion. And tonight's event will bring together academics and human rights advocates to address recent and upcoming Supreme Court cases and their impact on LGBTQ rights. In 2022, the Supreme Court decided some of the most consequential cases that implicate LGBTQ rights in the country's history, as I'm sure you are all aware. This includes Dobbs versus Jackson Women's Health, which overturned Roe versus Wade and has potential implications for cases that recognize a constitutional right to same-sex marriage and sexual freedom. This year, the court is poised to decide another case that will significantly impact LGBTQ rights as well. 303 Creative versus Elenis, which may limit anti-discrimination protections for LGBTQ people. At the same time, the court is poised to hear cases that could have a dramatic impact on transgender people at a time when state legislatures across the country are debating significant limits on their human rights. At today's event, we will discuss past and current court cases and how they might influence the lives of LGBTQ people in this country. Before we begin, I'd like to introduce each of our panelists in alphabetical order. And I also know from your programs, Heath Fogg Davis was unable to make it because of a family emergency. So we just have the three panelists you see before you today, and I'll introduce each of them to you now. So first we have Kevin Jennings. Kevin is the CEO of Lambda Legal, the oldest and largest national legal organization whose mission is to achieve full recognition of the civil rights of LGBTQ people. Formerly the president of the Tennant Museum, Kevin's contributions to the LGBTQ movement began in 1988 when he helped students create the first school-based gay-straight alliance club, leading him to found and lead the Gay, Lesbian, and Straight Education Network, or GLSEN, for 18 years. He then served as an assistant secretary of education for President Obama, after which he led the Arcus Foundation, the world's largest foundation for LGBTQ rights organizations, for 5 years. He is also a Lambda Literary Award winning author of 7 books, including his memoir, Mama's Boy, Preacher's Son, having been named a Book of Honor by the American Library Association in 2006. And he also helped write and produce the documentary Out of the Past, which won the 1998 Sundance Film Festival Audience Award for Best Documentary, and is the executive producer of the documentary The Lavender Scare, which I've actually shown in my class a couple of times. So we're really thrilled to have Kevin with us today. Next, we're delighted to have Shana Medley with us. Shana is a staff attorney at the Transgender Legal Defense and Education Fund, or TILDEF. Founded in 2003, TILDEF's mission is to end discrimination and achieve equality for transgender people, particularly those in our most vulnerable communities. TILDEF's strategies include path-breaking trans rights cases and front-of-the-court briefs regarding the key issues of employment, healthcare, education, and public accommodations. And Shana is a visiting professor at the Cardozo School of Law, teaching trans and reproductive justice. And previously, Shana was a legal fellow with the Center for Reproductive Rights, where they served as counsel on the Dobbs case and the ACLU LGBT HIV project, where their work focused on educational rights for transgender youth in schools. So clearly, Kevin and Shana will have a lot to say on the cases that we're going to discuss tonight. And finally, I'd like to introduce Joanna Wiest. Joanna is an assistant professor of politics at Mount Holyoke College and a former postdoctoral fellow in LGBT studies in the Princeton University Society of Fellows in the Liberal Arts. Her research focuses on identity, political economy, and American constitutionalism. Her work on the American LGBTQI+ movement has appeared or is forthcoming in Perspectives on Politics, Polity, Politics and Gender, Law and Social Inquiry, GLQ, and a number of other very prestigious academic journals. Her writing has also been published in major media outlets like The Nation, Boston Review, and the Philadelphia Inquirer. And her forthcoming book, Born This Way, Science, Citizenship, and Inequality in the American LGBTQ+ Movement, is at once a celebratory and cautionary tale delineating a minority rights movement's impressive victories, its powerful persuasive allies, and the inherent limitations of identity-based social movements and biopolitical citizen claims in the face of resurgent right-wing assaults. So Joanna will also have quite a bit to say, I'm sure, on the cases we'll discuss this evening. For tonight's event, I prepared a number of questions for each of the panelists. We'll start with just some general questions, and then I'll go to some more targeted questions on the Dobbs case, the 303 creative case, and the anti-trans legislation generally. And then we'll end with a couple of general questions as we have time. The last 15 minutes or so we'll spend on Q&A around 5:50 to 6:15. Usually we try to end by 6:15. And once we end, you're more than welcome to meet us upstairs for a reception on the first floor by the patio. I keep forgetting the name of that room, but it's right to the left as you go upstairs on the first floor. So without further ado, I guess I'll just go ahead and ask the first question, and as you are answering, I'll move to the table. So first, I've described all of your work, but it's more sort of general what you've done over time. So I would also like you each to begin by describing your work, including legal and academic work that you've done in LGBTQ legal rights, and especially more recently. So let's go ahead and do that.
Thank you so much, Erin, and thank you for the introduction. I guess just to add, a lot of what I'm currently working on at TILDF is a lot of jails conditions work. So we bring impact litigation to improve the lives of trans and non-binary people in several key areas. And a lot of the work that I'm currently doing involves trying to get policy changes as well as monetary compensation for trans people who are mistreated in county jail systems. And as Erin mentioned previously, I was at the Center for Reproductive Rights, where I was part of the large legal team working on the Dobbs versus Jackson women's health case. And in addition to that, also teaching at Cardozo Law School this semester, and I've published a few articles at the intersection of trans and reproductive rights. I'll end there. Pass it to Evan.
Excuse me. First of all, thanks, Erin. Thanks for inviting us to be here today. Lambda Legal went through a strategic planning process about 3 years ago, and we discovered that we were engaged in 27 different buckets of work, which was a lot. And we went through a prioritization exercise where we decided that we would rank everything we did from 1 to 27 using 2 criterion. First of all, how much would people's lives actually get better if we won? And number 2, could we win? And at the end of that, we had a nice grid of 27 different boxes, which is totally unintelligible to average human beings. So I said, can we get this down to 1 sentence? And we did. And what Lambda Legal does is it wins new protections for the most vulnerable in our community while defending the community from attacks. Now, we have prioritized 7 populations as the most vulnerable. These are in no particular order: trans people, people living with HIV, LGBTQ plus youth, LGBTQ plus immigrants, LGBTQ plus seniors, people facing systemic discrimination in the legal system like LGBTQ plus people of color, and people facing systemic discrimination in areas like housing and public accommodations. The attacks, which I assume we're going to discuss in great depth today, I don't need to explain to you, but I will tell you, I write my board a update memo on the first day of each month. As of today, there have been 336 anti-LGBTQ plus bills introduced in 37 different states. So there is a tidal wave. It has already exceeded the number last year. And remember, Florida's just coming into session, so they're just getting busy down there. So the number of attacks is astounding. We right now have 72 active cases in 20 different states, the bulk of which are designed to overturn some of the hateful legislation that's being enacted.
Can Can everyone hear me okay with this one? All right, excellent. Well, it's so good to be here with you all tonight, and thank you so much, Aaron. Like Aaron said, I'm a political scientist. I study mainly LGBTQ plus civil rights and American constitutional law more broadly. And some of the work that I've done that I think is informing the way that I look at some of these current bills and litigation and all sorts of things affecting queer rights today is one, that book project that Aaron mentioned, Born This Way. So there, I was really interested in how activists and attorneys, but also scientists and scientists who were interested in kind of combating these older ideas that being queer was a sign of mental illness or being trans was a sign of mental illness. Very interested in how all those kinds of actors and organizations came together to combat those ideas and then to kind of bring those scientific ideas and reforms into the law and into legislative debate to change the terms of the debate and then to change the laws. And so that's kind of informing how I'm looking at what's going on today in terms of we see more of these kind of anti-trans litigation attempts to use biology to frame biological sex as the way that we're going to determine what kind of rights folks get, what kind of facilities they can use, what kind of gender markers are going to be on their licenses and passports and all sorts of documents like that. We also see a rise in the same sorts of older social contagion myths. So in the past, we used to see queer people targeted as a sign of some broader social malady that was spreading and corrupting children in particular. And I think we see that kind of rhetoric heating up today in discussions over trans kids in particular. And so that kind of scientific debate is playing out in legislatures and courts and in the public sphere right now too. And so, again, I'm so excited to be here with you all today and to talk about how all of these issues are playing out before the Supreme Court, but also in state legislatures.
Thank you all for talking about your current work generally. I guess I'd just like to start with a general question about the Supreme Court. So how would you describe the current court's treatment of LGBTQ rights in comparison to other constitutional rights?
With regard to other, one thing that folks might be familiar with is the way that the free exercise clause in the First Amendment, protecting religious liberty, is kind of broadly how we think of that amendment or that particular clause of the First Amendment being read. How free exercise of religion has warped from this thing that throughout the 20th century protected a variety of different minority religious rights and still does in many important respects, but also now is kind of being pit against LGBTQ plus rights, reproductive health rights, in this kind of zero-sum game where we see litigation being filed by conservative groups appealing to the conservative six-justice majority on the Supreme Court in ways where we see kind of instances where the court debates whether if you're a Christian baker, whether you have to serve queer people according to the way that we normally read anti-discrimination laws that impact your particular city or state, whether that you might have this kind of free exercise of religion right to discriminate. We also see, I think, more broadly than wedding cakes and the sorts of services like that we normally kind of are used to talking about in the context of that religion versus queer rights battle. We're also seeing some of those groups that are really funded by a lot of kind of very powerful millionaire and billionaire kind of organizations. Charles Koch is a name that comes up oftentimes in this litigation. Betsy DeVos, a former Trump administration official, comes up in terms of the leadership of the networks that many of these groups are involved in. And the way that the Free Exercise Clause is used in some current and ongoing cases would protect whole religious hospital networks from having to give trans men hysterectomies, for instance, or providing any kind of gender affirming or any kind of wide variety of reproductive health care services that we might expect your kind of average medical institution to cover, just because they have the cover of saying, well, we have a First Amendment religious liberty right to deny queer people and to deny pregnant people those kinds of services. And so I think that's just one place where we're seeing one part of the Constitution being kind of used to erode some of these newly won queer rights and reproductive rights.
Great, thank you so much for that response. I think now we can just move on to the Dobbs case. So as I'm sure you're all aware, in the summer of 2022, the Supreme Court decided Dobbs versus Jackson Women's Health, which overturned Roe versus Wade and eliminated constitutional protections for abortion. So how might Dobbs impact LGBTQ rights, and does Dobbs place any precedents that deal with LGBTQ human rights at risk? And I guess to open this question, I'd like to direct it to Shayna, since they've worked on this case.
Sure, thanks, Erin. So I can maybe start by just giving a little bit of background on the Dobbs case, which I'm sure everyone is familiar with to some extent. But basically, this was part of, a long history of anti-abortion advocates trying to get cases to the Supreme Court, eventually to a court that might consider overturning Roe and Casey. And so, Mississippi passed a 15-week abortion ban, which was clearly unconstitutional under prior precedent, which had established viability as the point at which states could not ban abortion, which was around the 22 to 24-week mark, so 15 weeks was well before that. So when the court granted cert in Dobbs, it was already a very alarming sign that the court was even taking up this question. And, I think we, expected, unfortunately, a loss. Didn't know exactly what it would look like, but ended up, wholesale overruling Roe versus Wade and Casey. And I think, there's a lot of concern about, what the Dobbs case could mean for other substantive due process rights, other rights sort of grounded in the same liberty rights that the Roe decision was grounded in. The majority opinion attempts to sort of cabin its opinion, say that it's only talking about abortion. Abortion is somehow different from this other line of cases, protecting things like contraception, the right to same-sex intimacy, to same-sex marriage. But, people are justifiably concerned that those precedents are also in jeopardy because they rely on so many of the same principles and reasoning. And, I would just add that in addition to, the future possibility that those precedents might be overturned at some point in the Supreme Court, I think there's also, a very present threat to trans and non-binary people right now as a result of Dobbs. I know we're going to talk about a lot of the anti-trans legislation a bit later on this panel. And certainly there was a lot of anti-LGBT, anti-trans legislation even before Dobbs, but I think we've seen that really increase exponentially. A lot of the same groups, as Joanna mentioned, anti-abortion, anti-trans groups are sort of funded by the same people, oftentimes the same groups that are bringing this type of model legislation. And, I think they've been really emboldened by the Dobbs decision to, bring, to pass legislation that might, at this point in time, be unconstitutional in an attempt to reach a Supreme Court that, might overrule it. We see a lot of parallels between, attempts to ban transition-related healthcare and bans on abortion, laws that, are styled sort of similarly to, folks may be familiar with the SB 8 law in Texas, the sort of vigilante law that, attempted to ban abortion through private enforcement. There's sort of model laws that have been introduced along the same lines when it comes to trans healthcare. So I think, that I would say is one of the most kind of pressing threats is, the ways in which groups that oppose, trans rights and abortion rights have been emboldened to attempt to pass this kind of legislation.
Anything?
Well, I'm old enough to remember an ad campaign for Lay's potato chips back in the 70s and 80s. And the ad campaign slogan was, "Bet you can't stop with just one." And it turns out the conservatives on the Supreme Court can't stop with just one. They took down the Voting Rights Act in Holder versus Shelby County back in 2013. They took down reproductive rights in Dobbs. They have a shopping list. And LGBTQ plus issues are on it. So I think that we should be very prepared to see those landmark decisions challenged. And I would not be surprised to see them overturned, given the extreme ideological twist of the court, thanks to the stealing of the seat that should have been Merrick Garland in 2016, as well as the ramming through of Amy Coney Barrett in 2020, and two of the most egregious misuses of Senate power in American history. And just to keep you up at night, if Amy Coney Barrett serves to the same age as Ruth Bader Ginsburg, she'll still be on the bench in 2059.
Well, that's indeed a long time. So I guess as a follow-up, there's also been, I found it really fascinating that all of you have brought up that this is connected to sort of a broader counter movement. Is there anything that we might be able to do on the ground outside of the court to help realize LGBTQ human rights and reproductive rights in the wake of Dobbs? I'm thinking like potential constitutional amendments or other things that we might be able to do to help, I suppose, ensure rights in the wake of lack of constitutional protections.
I'll actually take this one because we advised the Illinois State Legislature recently, and they created basically a safe haven law for people seeking reproductive health care and gender-affirming care in the state of Illinois, so that if people in other states can't get that care, they can come to Illinois and get it and be safe while they're there. So I think that that would be a good example of some things we can do. The reality is we're going to lose in a lot of states because we just don't have the votes. And that makes the work of TILDEF and Lambda Legal and NCLR and other allied groups critically important, because our last line of defense is going to be to get these things struck down in court. Because we don't have the votes in Florida. We don't have the votes in Oklahoma. We don't have the votes in Texas. We don't have the votes in North Dakota. We just don't. So the courts become our last line of defense. So I think that it's absolutely critical that where we have progressive leaders, that we get them to enact new laws like the Illinois Safe Haven Law, and where we don't have progressive leaders, that we leverage the courts to the greatest extent possible to stop some of the most egregiously defamatory bills that are now being written into law across the country.
Thank you all for those responses. Before we move into the anti-trans laws, which I'm sure everyone is wanting to jump onto, I just wanted to briefly touch on another upcoming case, the 303 Creative case. So this year, the Supreme Court is going to decide 303 Creative, which is a case that challenges Colorado's anti-discrimination protections for LGBTQ people. And the case asks whether First Amendment free speech protections give at least some anti-LGBTQ conservatives a conservative right to violate civil rights laws. And can you tell us a bit about this case, or sort of why it's so concerning and what you think might happen with it?
Sure. So, this is the second case that has gone up to the Supreme Court sort of on this broad question, the first being the Masterpiece Cake Shop case, which the Supreme Court essentially punted and didn't reach, the actual merits of the question of whether, anti-discrimination laws, public accommodations laws implicated free speech for people who, owned a business who didn't want to provide services. And this case is sort of interesting and different in, a concerning way as well, in that there's no actual kind of person on the other side of it. The plaintiff challenged the Colorado public accommodations law just sort of in anticipation of the effects on her business and alleged speech, but had not actually been asked by anyone to make a website or a product for an LGBTQ person. And I think for that reason we've sort of seen less in the media about the story, because there's actually less of, there really isn't a sort of person on the other side of it. And I think it's scary in that it's hard to see a limiting principle if the court does rule in favor of the plaintiff, the business owner in this case, who doesn't want to provide services to LGBTQ people. And it has the potential to impact all sorts of public accommodations laws. So it's definitely frightening that the court decided to take this up again. Hard to predict exactly what they'll do, or how they might potentially try to narrow the opinion, but it definitely has a lot of concerning implications. Kevin or Joanna, if you want to add anything.
The only thing that I'll add, it's an excellent summary of kind of what the stakes are and what the arguments are in these developments. I think it's just noteworthy how many different fronts these groups have tried to fight to limit civil rights law in this particular way. So in 2021, there was a case that didn't deal with free speech as much as it dealt with free exercise of religion again, and that was dealing with Catholic Social Services, a foster and adoption agency that did home study certifications for would-be parents in Philadelphia, using notably public funding to do those home studies. And the Supreme Court, in a more narrow opinion, but still in an opinion, decided that Catholic Social Services could discriminate against queer couples, queer married couples, based again on kind of religious liberty grounds. So it's just kind of, there are a few different fronts that I think we have to look at where this is developing. Is it going to be a free speech expansion? Is it going to be a religious liberty one? But it all points kind of to the same ultimate end here, which is the kind of slow erosion of civil rights protections.
Yeah, it's kind of ironic we're sitting here and the four freedoms are right in front of us, the first of which is freedom of speech and expression. The conservatives have a very conflicted relationship with the idea of freedom of speech. They want to be free to say they hate us, but they don't want us to be free to say who we are. So they're perfectly happy to limit freedom of speech with the so-called don't say gay or trans laws, or the efforts to ban drag performances. They're very happy to contravene people's rights of freedom of speech, but they're very insistent that they should have the right to discriminate and that is their freedom of speech. There was another case in which we filed an amicus brief last June, which was very disturbing to me as a former high school teacher. It's what I call the praying coach case, which was in Bremerton, Washington, where the football coach would go out in the middle of the football field at the end of games and lead a prayer. And of course, that is a violation of the separation of church and state because he's a public employee. And the court ruled that it wasn't, that this was his just exercising his freedom of speech. And the fact that he was the football coach, and whether or not you might gain a little favor if you followed the coach onto the field and prayed with him, didn't seem to sway the court very much. So there is this very, very curious freedom of speech battle going on right now, where they want to limit our ability to express who we are while expanding their ability to express their hatred of us.
Thank you all for your responses. And just to, since we've started talking about the state legislation, I guess we'll just jump into some just general questions on the anti-trans laws. So we've talked about a large number of attacks, mentioned a couple, but just to not assume any prior knowledge from the audience, what are some examples of recent or current laws that you see attacking the LGBTQ community, and why do you find them so concerning at the state level?
Where do we start? In our analysis that we did for our board, actually, just in the last 24 hours, the two top categories for these laws that are being proposed in the states are education and healthcare. In education, some of the examples are banning trans young people from being able to participate in school sports, preventing trans young people from being able to use the appropriate bathroom, preventing teachers, students, and families from discussing their identities with the so-called Don't Say Gay or Trans laws. The large bulk of the healthcare bills are around bans on gender-affirming care for trans young people. So those seem to be their two primary lines of attack. And it's not a surprise to me because what you'll notice, these are, I think Joanne said this in her intro, that a lot of this deals with youth. And there's a reason they start with youth. Because if you want to get people irrational, tell them somebody's after your kids. That has worked throughout history. Supposedly Jews drank the blood of Christian children and that justified pogroms. Supposedly the Roma stole children and that justified the persecution of the Roma in Europe. Supposedly black men were after little white girls and that justified lynching. And supposedly LGBTQ plus people recruit. They groom and that justifies discrimination against us. Florida has a particularly ugly history in this regard, beginning back actually in the 1950s, when there was a special legislative commission called the Johns Commission, which led a witch hunt for LGBTQ plus teachers in Florida's schools. Then in the late 70s, there was the so-called Save Our Children campaign led by former beauty pageant contestant Anita Bryant, who led to the repeal of the Human Rights Ordinance in Miami-Dade, and now there's Governor DeSantis and his Don't Say Gay or Trans law. So it's kind of eerie and creepy to watch history repeat itself, but it repeats itself because you know what? It works. If they can make people panicked, which is what their ultimate goal is, panicked people give permission to evil laws. And that's their strategy. And that's why you'll notice that virtually all of these laws somehow deal with young people.
So I guess just as a follow-up, because you talked a bit about history, I remember back in 2016, I was finalizing some research for my book, which is on queer coalitions at the state level. At the time, we were seeing a lot of similar legislation coming up attacking the trans community, but it was failing, even in more conservative states. So what do you think has happened between 2016 and now that we're seeing a lot of these, most of them, or many of them are still failing, but we're also seeing some very high profile ones pass, like the Don't Say Gay law in Florida, the various actions against trans youth we've seen in states like Texas. There was one last week in Tennessee, the anti-drag bill. What do you think has changed over the past few years?
Sure. I mean, I think I talked about this a little bit with the Dobbs summary, but I mean, even before that, the composition of the federal courts has changed quite a lot, not just the Supreme Court, but, Trump appointed an extraordinary number of judges to the federal bench. I think something like a third of the judges on the Court of Appeals, which, really sort of changes the landscape in terms of, what types of legislation might actually be upheld. And I think, as you were mentioning, Erin, I think a lot of these bills, particularly we sort of have seen, the strategies kind of shift we saw a lot of these bills banning trans youth from restrooms and locker rooms. Most of those failed, as you said, even in, more conservative circuits. Then, we get a shift to school sports and now healthcare. And I think, certainly the Dobbs decision has emboldened people to try to bring more of these types of legislation that previously may have failed in court. And there's just a sense of try everything and try to get in front of a judge that might uphold this. And I think that's really been part of the reason why we've seen such an immense exponential kind of increase in these types of bans.
So just sort of piggybacking off of that, how do you think challenges to these laws will fare in the courts? If you could think of specific examples, that would be great. So one of the things I'm thinking of is the bill, and this is on my mind just because it was like 3 days ago, like in Tennessee, well, Thursday or Friday in Tennessee, the anti-drag bill. It seems pretty clearly to have First Amendment implications. Do any of these laws violate constitutional rights? And if so, do you think they'll be overturned in the courts, especially given that we've seen this sort of right-wing shift not only at the Supreme Court, but also in the appellate courts after the Trump administration was so successful at appointing conservative judges?
I don't know. As a political scientist, I feel like we've learned over the last few years not to make predictions. But if I haven't learned anything, I would say to this point about the judiciary really being changed, the federal courts really being changed by the Trump administration, I think we see that in terms of prior to the judiciary becoming more conservative leaning, there were many federal circuit courts of appeals, so that would be the federal courts right below the United States Supreme Court, had found that there were some kind of constitutional and statutory protections for trans kids who wanted to use the bathroom that best matched their gender identity in K through 12 public schools. But now, a few months ago, we just got, I believe it's the 11th Circuit Court of Appeals was the first to say that actually there are no protections as such for trans kids who need to use the restroom or locker room in their schools. And ironically, that was a decision that rested in part on a very conservative version of the right to privacy. So not the right to privacy that we think famously about in decisions like Roe v. Wade that protected abortion access, but rather a very kind of cis woman-oriented right to privacy to not be observed by a trans woman in a restroom or in a bathroom. And so that's a huge change in terms of that far up the federal courts. So I think some of these laws might have more of a chance of surviving judicial review than they might have a few years ago. But even if they don't, the education laws at the state level, for instance, like Florida's Don't Say Gay and these anti-critical race theory ban laws throughout the country, I see as what they're oriented toward is sowing distrust about public school teachers. Your public school teachers are the groomers and the abusers. And that's been working really well to demonize public institutions just at the moment that the DeSantis's of the world are also trying to siphon more and more money out of public education. So even if these laws survive, or even if these laws are struck down, rather, by the federal courts eventually, the kind of propaganda campaigns and the sowing distrust against public schools are really helping the broader conservative project of dismantling public education entirely.
Do either of you have anything to add? How do you think they'll fare at the courts? Or I guess I can move to my next question. This has been sort of a downer of a panel so far, which I think everyone was anticipating who was coming to today's event. But let's potentially an uplifting question. So we've covered a number of cases that have challenged LGBTQ rights. And has the current court decided any cases that you might see as expanding LGBTQ rights? I'm thinking specifically of potentially the Bostock case, for example.
Sure. For those of you who are not familiar with it, the Bostock case was decided in 2020. It was a consolidation of several cases in which it was ruled that Title VII and its ban on sex discrimination applied to gender identity and sexual orientation, and that therefore you could no longer fire people from their jobs for being LGBTQ. This was the product of a 15-year effort, which began with a lawsuit that was filed in 2006. So that's another thing to realize, is that we're not in the instant gratification business. The fights we're fighting take 5, 10, 15, 20 years. Lambda Legal filed its first same-sex marriage lawsuit over 20 years before Obergefell. So the great LGBTQ historian John D'Amelio often said that history proceeds by creeping and leaping. creeping are the decades in which you lay the groundwork, and then all of the sudden there's same-sex marriage. Well, there were decades of work before same-sex marriage happened, but it was below the surface of public consciousness. I'm not going to say the court is giving me hope at the moment, because it's not, but I will tell you what is giving me hope: the Gallup poll. The Gallup poll tells me that 1 in 5 members of Generation Z identify as LGBTQ+. That horse has left the barn, Governor DeSantis. You're closing the door way too late. And I really have tremendous faith in the next generation that they will get this right, because they understand, I think, many issues: gender identity, sexual orientation, race, in a much more sophisticated way that people my age did because of the way we were educated. So I think that's another reason why they're focusing with the Stop Woke Act and the Don't Say Gay or Trans law, et cetera. They're like, we have to stop young people from learning the truth, because when they learn the truth, all of a sudden they want to change the country. So that's not an accident either. So I think what gives me hope really is not the courts. I think that we're probably going to see some more downers out of the courts, but I think that the new generation and the leadership that it's showing is what's going to win in the long run.
Now, do you think there's anything that can be done to change the political trajectory of the court, either through Congress or otherwise? Just before I move to the audience.
Lambda Legal has come out in favor of court expansion. The reality is people naively think that the number of 9 justices is somehow written in the Constitution. It's not. It's an arbitrary number. And it doesn't even, our current structure doesn't even correspond with the arbitrary way the number 9 was set, which was to match the number of circuits we had at that time in the 1860s. Well, there's more than 9 circuits now, but there's still only 9 judges. I think there are other things that we might want to consider, such as a code of ethics for Supreme Court judges. Like if your wife tries to overthrow the government, that might be a bad thing. My partner has a T-shirt that says Jenny Thomas for prison. And I think that there really is a need for the court to be expanded and for appropriate limits to be put on justices in the way that every other justice at every other level in the American judiciary system is held accountable.
Yeah, I think the only thing I could add to that is that when President FDR threatened to pack the court in the 1930s, it wasn't just him. It was this massive mass movement organization of particularly workers and labor union leaders who were pushing and pushing and pushing FDR to save the New Deal, to save the sort of new regulatory institutions, to save the new sort of protections for labor rights and for average working people. And I think we could draw a parallel and understand that's why FDR was able to even make that credible threat, which did eventually get the Supreme Court to turn from being entirely sort of anti-New Deal and striking down all sorts of these protections to being something that was a little bit less willing to engage in that sort of radical judicial activism. And I think the reason, drawing that parallel, why President Biden had this kind of very weak tea commission that recommended some very kind of small reforms around the edges to the Supreme Court, and why we're not seeing more radical proposals from our leadership, is because that sort of pressure doesn't exist. And that's the sort of thing I think we need to build up outside of institutions to be able to get someone in the president's chair, like a President Biden in the future, to do something. There's a variety of things that do something could be, but to pressure the Supreme Court to hold back a little bit, to not be so willing to engage kind of in radical decision-making like we've seen the court do kind of in the last several terms.
Yeah, and just to add to that, I think, putting pressure on political candidates to also, have a progressive platform when it comes to lower judges too. I know we've been talking a lot about the Supreme Court, but even among quote unquote liberal kind of judges in lower courts, there's such an imbalance when it comes to the backgrounds of judges on the federal bench. The majority come from sort of government side prosecutor backgrounds, very few public defenders on the bench, people from civil rights litigation, and I think pushing Democratic candidates to have that be part of their platform to expand the diversity of the federal bench as a whole would be an important one.
Great, thank you all. I guess now what we'll do with our last couple of minutes is just sort of open it to audience Q&A, and we also we have Mac with a microphone, who's also, I think, going through online comments, right? Right, all right. Oh, I'll choose someone here, go ahead.
Thank you guys for such a great panel. I just have a question about, it's related to Professor Adams' last question, and Joanna mentioned it a little bit. The Biden administration, like we know in December, they passed the bill, Respect for Marriage or something. I was just wondering, to what extent does that, protect the same-sex marriage in terms of like protecting Lawrence versus Texas or Obergefell? Or how does these kind of bills, like how effective are they? And how will like passing similar bills in the future help protect like federally, LGBTQI rights?
It's important to recognize, first of all, great question, thank you, what the Respect for Marriage Act does and what it doesn't do. It does not protect Obergefell. What it does is it basically says that a state has to recognize valid marriages from other states. But our opponents are still going to try and overturn Obergefell, and we could return to a situation that existed when I was a young boy, which is when interracial marriage was still illegal in 16 states in this country until 1967, when the court intervened in Loving versus Virginia. So I think that there are things we can do legislatively, but the courts are going to remain a really critical lever. And also, not to depress you further, but with the House now in the hands of the conservatives, there's going to be no legislative fixes for the next couple of years. So, things that we once had hope for, like the Equality Act, are now very much on the back burner. And we're really going to have to work very hard in the courts, because that's going to be the arena in which a lot of these battles are going to be fought, because we're going to have legislative gridlock in Washington.
So over here.
Great job, everyone. I've really enjoyed the discussion. Thank you for coming today. I am in the Grove Fellowship, which I know you're a member of, and I'm in the ERA cohort. And so, yes, it's very exciting. For everyone, I'm sure you all know the Equal Rights Amendment has made a resurgence in public opinion anyway. They just had a judicial hearing on it. And, constitutional quibbling aside, sorry to dismiss constitutional law, but if the ERA were managed to be ratified, do you think it could be used to help with LGBTQ rights, or would it be mostly sequestered to women's rights?
Yeah, I think there's definitely potential for equal rights amendments to, both at the federal level as well as some states, be used to advance LGBTQ rights. I know we mentioned the Bostock opinion briefly, which, again, hard to say what, or have faith in what the current court will do in applying that decision. But, I think that decision does make clear that, prohibitions on sex discrimination apply to discrimination based on sexual orientation and gender identity. And I think, ERA protections could be used in a similar way. Again, hard to say what, judges interpreting that would do, but I think it's definitely something that has a lot of potential. And at the state level as well, states that have equal rights amendments could certainly be used in that way too.
Let's move it over to the back.
Kevin, you mentioned taking a look and possibly reforming the Supreme Court. I believe you were suggesting that they should increase the number of individuals to go on the court. How do you deal with that particular thing, and so it doesn't become such an overt situation where somebody will decide to add 2, then another party will come in later on and say, wait a second, I don't like those 2 guys, I'll add another 2, and you know, it just
Next thing
goes
you know,
on.
you
It
have a
just-
Supreme Court of 94 people, yeah.
Right, at the end of the day, it just becomes, let's just add people, don't counterbalance, you know, the other side in terms of opinion. And the other question I had specifically is regarding the Equal Protection Clause of the Constitution. Why doesn't that seem to carry much weight? I think Ruth Bader Ginsburg, in fact, talked about that as a basis of when, you know, they were deciding Roe, that they should have went on that angle. And so I asked that question as well.
Our rationale is the historic size of the court has corresponded to the number of circuits in the country, and that should be the size of the court. You know, the fact of the matter is our court system is radically overburdened right now. There need to also be expansions at the lower levels as well. There's just not enough. The amount of litigation has escalated, and the number of judges is not. So we just need more capacity in our court system, period. And I think it's fair to say there should be the same number of judges as there are circuits. And if people come back and say, well, now I want 2 more, it's like, well, what's your argument? We're following the historic standard that led to the creation of the 9-member court in the 1860s. What do you argue other than just pure politics? And since you were at CCR, I'm going to let you take the second question.
Sure. Yeah. So with respect to your question on the Equal Protection Clause and whether that could be used to, protect abortion, I think, the Supreme Court basically in dicta, that question wasn't even before them, but the majority in the Dobbs case did go out of their way to say that the Equal Protection Clause wouldn't protect abortion either. And, unfortunately, I think with the Supreme Court that we have now, it's really not about what constitutional argument is before them. They're, just not willing to recognize the right. That said, there have been, some district courts that have decided opinions on the basis of equal protection when it comes to reproductive rights. I think there's perhaps a much sort of longer term strategy of looking to other constitutional amendments that could potentially be used in the future, at some point down the road that reaches a different Supreme Court, and we might be able to get, a decision on those grounds. Equal protection is one. Some scholars have also advocated for using the 13th Amendment's prohibition on slavery and forced labor as an argument as well. There's actually a district court judge in DC who ordered the parties to brief that question in an abortion case. So we might see, other constitutional theories kind of percolating through the courts and, eventually reaching a different Supreme Court.
I also see Professor Magponte in the back.
Hi, how are you? Comment and question. First, on the comment, I know it's a downer, but the one piece I want to say is that there's there's 11 circuits, there's a lot of district courts, there's a lot of state courts. The Supreme Court might not be there, but they cannot take every case. And there's so much good that we can do at the district, at the court level, and the state level. So it just, I think, a shift in strategy. So that's good. So I wanted to ask a practice question at the Supremes. So I haven't practiced, I haven't filed a brief in a couple of years. So I just wanted to ask y'all, how are they looking at amicus briefs now? Pam Carlin at Stanford Supreme Court Clinic and I had always argued that she's like, we need just a few really good briefs. And I'd be like, Professor Carlin, everyone's going to answer, so there's going to be a ton of briefs. And so we've always argued respectfully on that point. I haven't practiced before this court now, and so my question is, has the practice of amicus brief changed? Are they looking at more, less? Are they accelerating? Because that's always been a place where we not only change laws through courts of law, but also through courts of public opinion. And that's a dual strategy there.
Oh, first of all, good to see you, Glenn. I'm really hoping that amicus briefs do not turn into letters to Santa, given the current composition of the court. But building off something Shana said, part of Evan Wolfson, who is a former Lambda attorney, who was one of the masterminds behind the drive for equal marriage, used to talk about the concept of losing forward, that you knew you might lose a case or lose a referendum or lose a particular battle, but you were planting the seeds for future victory. And when you were talking, that's exactly what I was thinking. That's basically what you were describing. The seeds, the constitutional seeds we plant now, whether it's in amicus briefs or in actual cases, become the flowers of 10 years from now. So I think even though I'm very concerned about the letters to Santa phenomenon, I think we still need to engage in that work because we're planting the doctrines that future judges will rely upon to make more favorable rulings. So I think that they're still very important. And I think that what we need to be doing right now, if you look at all of these fights, like for instance, Bostock took 15 years, Obergefell took 20 years, Lawrence versus Texas took 30 years. We need to be thinking 20 years ahead and planting the constitutional doctrines now that the Gen Z judges will pull out 20 years from now and say, you know what, that dissent, that was actually the right ruling. And we're going to follow the reasoning in that dissent.
I see over here.
Hi, thank you all for this panel. It's been really enlightening, and I appreciate the time that you took to talk about all of this. We actually are all in Professor McIntyre's class. Anyway, very
They
specific.
better be getting extra credit, Glenn.
Very specific question, thinking about trying to put pressure on the courts as, just common citizens who, it's not like I can go call up President Biden and tell him to do anything, right? And thinking about how the court seems to just have a mind of its own right now. A lot has changed. It seems like they're not really following the Constitution. They're overturning decisions that have been precedent for a long time. I'm wondering how all of you guys feel about potentially targeting term limits, like maybe not having lifetime appointments so that we don't have to wait 20 years down the line to see any new judges come, or if there are any other things that we could be advocating for to change the court itself without having to wait around for things to change.
I'm just going to push back on the first thing you said, which is you should be calling President Biden. And the reason I say that goes back to what Joanne said earlier. The reason why the court moderated in the 30s was because there was a mass movement by the citizenry that said, you are too extreme and you need to stop. So having worked in an administration, in the Obama administration, I could tell you those calls matter. And the other side, frankly, is a lot better at them than we are. A senator who shall go unnamed, who was one of the sponsors of the Respect for Marriage Act, told me that even though she was a sponsor of the act, she was getting 10 times the number of calls against the act than for the act. And congressional staffers tally up the number of calls every day, and they report a total to the senator. So call the president. Don't be shy. And because I think we need to create a grassroots movement on the ground that says you need to consider things like term limits. You need to consider things like court expansion. You need to consider things like a code of ethics for Supreme Court justices. Frederick Douglass, the great black civil rights leader, said, power concedes nothing without a demand. So make the demand.
And I'll give you the phone number.
Aaron, can I just add something to that really quickly? I think in addition to calling, because I think it's a good idea, why not? The other thing to think about for thinking about the parallel from the 30s is that organized labor was much more powerful during that period, and there were these kinds of groups that could press against the court. And I bring that up because the folks who are funding the attack on all sorts of minority civil rights are also, and reproductive rights, are also the ones who are funding attacks on the labor movement and collective bargaining. So Jonathan Mitchell is the author of SB 8, that 6-week abortion ban in Texas that we kind of don't talk about as much now because of Dobbs. But that was this hugely radical law in Texas, But Mitchell was more known in his circles for being a rabidly anti-union and anti-labor law attorney, and was responsible for cases like Janus before the Supreme Court case that really eviscerated public sector unionism. So if I think about the thing that the Supreme Court wants you the least to do would be to organize your workplace, join your union, be a union leader, and to create the kind of movements and organizations that could actually get the attention of people in power. And I think that's exactly what those forces don't want you to do. So I would consider doing it.
Quickly respond that my workplace just held a union election. It's very funny that you mentioned that. But yeah, I completely agree with you.
See, we have.
We did not win, unfortunately, but the fight is not over.
All right, so let's take, we've had someone over here waiting a while, and then we should probably take a couple online, right?
If I understand you correctly, you had said that there are laws either being promoted now or have been put into effect that have negative effects on reproductive and transsexual health care. I have no idea what you're talking about. So would you please explain that? What is the health care of transsexuals being negated? You know.
Yeah, so there's been a huge movement to attempt to ban any sort of transition-related healthcare, majority targeted at youth. So oftentimes youth who are on puberty blockers or hormone replacement therapy, there are states that try to criminalize getting that care in the same way that they have tried to criminalize getting abortion. Some of the proposed bans go as far as to ban trans healthcare for adults as well, criminalizing both providers and people who seek the care. So really just attempts to wholesale ban being trans in a lot of these places, many of which are modeled after the attempts to ban abortion in many places.
Should we do that?
Yeah, so I'll share a question from one of the attendees joining us on Zoom. Michaela Griffo has a comment and a question. Amy Coney Barrett made it clear that the Supreme Court is the judicial branch of the government, not the legislative branch. Given that, why do we, the LGBTQ community, not go after our congresspersons and hold them accountable for some of these anti-LGBTQI laws, instead of waiting to see how the Supreme Court will rule on some of these very contentious issues?
First of all, I think we should be doing, my answer is, should you contact the president, or should you contact your congressperson, or should you bring a lawsuit? My answer is yes. Do it all. The majority of these anti-LGBTQ plus laws are originating at the state level. And I know we would like to imagine it's just one or two outliers, but like I said at the beginning, it's 37 different states. But you'll notice they're not bringing them often in California and New York because they know they don't have the votes. So they're bringing them in places where they have the votes. So it is absolutely critical that we do electoral organizing, that we put progressive candidates and out LGBTQ plus candidates in office so that we have a voice when these horrible things are being proposed. During the Obama administration, I'm sorry to say, the Democratic Party lost over 900 state legislative seats. There was a concerted takeover of state legislatures and an extraordinary amount of gerrymandering done by the extreme right, so that there's a really great article in the New Yorker about 4 months ago about the state of Ohio and how its state legislature has been gerrymandered so that Democrats basically have no hope. So I think we have to do some really good electoral organizing, while also recognizing that the majority of gains that have come for the LGBTQ plus community over the years have come through litigation, not legislation. You know, I meet a lot of people who are not as involved who think President Obama legalized same-sex marriage. Well, I worked for President Obama and I love President Obama, but he did not legalize same-sex marriage. The Supreme Court did. And if you look at virtually all of our major advances, they've come through legislation, not litigation, not legislation. So while I think we should be absolutely engaging in electoral organizing and holding our elected leaders accountable, we have to have a multi-pronged strategy that attacks every branch of government, executive, legislative, and judicial, and does that attack not only at the federal level, but also at the state level, where our opponents have been very strategic and they've succeeded in taking over state legislatures, and we're now paying the price for that.
I think we have time for one more question. I think this person right here has had their hand up the whole time, so.
Hi, thank you so much for your time today. A question I have is, so many of us here at Hunter are, future people that are going to be engaging in these spaces. And one of the great challenges is a lot of times this kind of feeling that we have to tone it down, we have to assimilate, we have to talk how they talk, because if we make them feel uncomfortable, we won't be given access to those spaces. As people that have been engaged in these battles for so many years with so many different iterations and changes, what are some words of encouragement or advice you have for those of us that, are in that funny space of binaries and transitioning and like saying, and like, for example, in my case, I'm personally delaying my transition because it's like, am I going to be like figuring out, in the next couple of years or so, if it's going to be safe enough for me to just even, go across country to do, whatever career I seek to pursue. So I just appreciate honesty.
The way we expand the boundaries of what people are comfortable with is by being ourselves, even if that makes them uncomfortable. I lived through the AIDS crisis. I saw my first boyfriend die, saw my college roommate die. The only good thing that came out of AIDS was before AIDS, most Americans did not know an out gay man. And as a result of AIDS, they met out gay men. And something that America was once very uncomfortable with, America became more comfortable with. Right now, over 70% of Americans believe they've never met a trans person. Now they have, but they just don't know it. So I think by each of us living our authentic selves, we push the boundary of what is normal or comfortable or acceptable. And so I think by just being yourself, you're being heroic because you're pushing that boundary. So thank you. And I had a college classmate who wrote a great book called Should I Wear My Nose Ring to the Interview? Her answer was yes, because you probably don't want to work someplace where you couldn't wear your nose ring. And I'll tell you the dirty little secret of hiring, because I've done a lot of it. Resumes get put in 3 piles. The, oh my gosh, I've got to meet that person. The, why did they apply for this job? They're totally unqualified. And then what I call the B pile, which is, well, they might be able to do the job. If nobody in the A pile works out, I'll take somebody from the B pile. Nobody ever gets pulled out of the B pile. You always pick somebody from the A pile. If you are authentic, odds are you'll be in a lot fewer B piles. You'll probably be in more C piles, it's true, but you'll probably also be in more A piles. So not being who you are is not a sustainable strategy or a successful strategy. The number one thing that has proven in survey after survey after survey to reduce prejudice towards LGBTQ plus people is if you know an out LGBTQ plus person. So just by living your life, you're changing things. And we're in the business at Lambda Legal. We stake out positions that people think when we stake them out sometimes are nuts. I'll give you a very specific example. 7 years ago, we began representing Dana Zim. Dana Zim is an intersex, non-binary veteran in Colorado who wanted a passport and did not want to check either male or female because that was not accurate. And we took that case, and when we took it, a lot of people rolled their eyes because they were like, you're never going to win that one. Well, damned if Dana didn't get their passport last year with an X marker on it. So you got to stake out the right position The other side does it, like you were saying a minute ago. They pass these outrageous, unconstitutional bans, and they move the goalpost towards their ideal world by doing that. So let's stake our claims out there, because that's what moves the frame of reference. That's what moves the goalposts. So we're never going to win by playing it safe. There is no evidence in LGBTQ plus history that that is a successful strategy. So why start now?
I mean, just one final point. You mentioned sustainability and just, thinking about what it takes to do this kind of work and, feel like we can keep going. I feel like, being yourself, being in a place where you enjoy your colleagues, where you are working with people who have the same, sort of mission and values, I think, what Kevin was saying about interviewing, like you want to make sure the place that you're working is just as much of a fit for you as vice versa. And so, looking for places where that would be, I think is really important and crucial to be able to, keep doing this kind of work and showing up every day.
All right, with that, we'll go ahead and end. I do want to say a couple words about a couple of upcoming events that we have for the spring. On March 29th, we're going to have a Transgender Day of Visibility event that we're putting on with the New York City Human Rights Commission. And that event is going to feature several local trans advocates. So I strongly encourage, it will be here, yes, everyone to attend that. We also will have a workshop for students on April 25th that will provide lunch on name changes, gender changes, and navigating the CUNY process. That's going to be conducted by a law student from the CUNY Law School. So if you're interested in that, please be on the lookout for emails from our center. We'll also have a book event on featuring an upcoming release from an LGBTQ author on April 27th. We haven't quite confirmed who it'll be yet, and as soon as that happens, I'll go ahead and send out a release. And then students should also be on the lookout for emails about the Pride Policy Fellowship. We'll be selecting students to receive $5,000 to support an unpaid internship over the summer or undergraduate student research on LGBTQ policy issues. So that's a lot of stuff we have coming up. I would like to thank all the panelists for being here tonight to talk about LGBTQ rights in the Supreme Court. The director of the Policy Institute, Harold Holzer, Mac Barrett, who is handing you all the microphone, our curator of public programming, Peter Sclafani, the Roosevelt House Administrator, Alexis Fisher, who's our LGBTQ Policy Center Program Assistant, and all the staff at the Roosevelt House, as well as all the audience for making this such a wonderful event. Yes, thank you. Please feel free to join us upstairs for reception.